So, if you're entering into this industry, you may have heard that there is a quite a busy business of selling and buying retail energy providers. In some cases, it's sale of the entity, and a acquiring buyer will just simply acquire the entity and keep its management in place. In other situations, they will sell the company's assets, essentially the customer contracts, to the willing buyer. In the situation where you have an entity sale, then there's a question of whether there's a requirement in the various states to get some kind of approval from the commissions regarding a change in control. So here's the good news. For the most part, except for New Jersey, no state really requires a approval of the commission prior to the change of control. However, most states do require, after the change in control, to give notice to the commission. Sometimes it's within a set period of days. Sometimes it's just on the basis if there's a material change in the original application, which could mean under the management, technical, and operational requirements, if personnel have been changed out because of the acquisition and there are new people in place that are necessary to qualify for qualifications in those categories. In that case, you will, within a reasonable period of time, you would have to notify the commission. Again, that won't result in necessarily an approval process. It's more like a situation where they would call into question if they had any issues, and you may have to bolster your personnel if that were the case. But for the most part, again, all change of controls will be approved. In some cases, the change of control need only be announced in the annual report. And finally, even in Rhode Island, for example, it doesn't seem to be any requirement to explain to the commission that there's a change of control. Having said all that, and being sort of a practitioner in this area and dealing with regulators, I think it would be best practice for all concerned if there's going to be a change of control, and if there's going to be a change in personnel, and even if there's not a change in personnel, it would be a professional courtesy to reach out to one of the regulators that you're dealing with, somebody from the staff, just to let them know that you are in the process of having a sale and that there'd be a change in ownership by the ultimate investor or another operating company, and just give them that heads up so that when the PR reports go out, the notices, press releases go out, they will not be surprised. And regulators never like to be surprised. So it's always a good idea just to give them the heads up. And if they have any questions, you can follow up before they have to ask you, especially if they're embarrassed because they didn't know about it. So that would be my recommendation. I have created a table that lists all of the states, lists the requirements with respect to prior approval, post-approval, post-notices, timelines, the URLs to the rules that govern change of control type changes, and a copy of the actual rule so you can refer to that to get your own comfort about what requirements are to be made and when. So again, I'm hoping to make your life easier, having consolidated all this information in this multi-state survey. Please Google it and look it up in my article and on change of control requirements for retail energy providers. And feel free to download it. Once again, it's for you to use, but obviously periodically check on it to make sure that the rules hadn't changed in this regard. And again, good luck with your business efforts.